I want to start out by talking about the temporary court order that the Minnesota Department of Human Rights obtained within a week of announcing this investigation, which resulted in early and significant public safety changes in Minneapolis. One clear example was the requirement that the city implement a policy banning all chokeholds and neck restraints without exception. Another example is that at the time the court order was entered, at least 65 completed police misconduct cases were sitting on the police chief's desk awaiting review. At least 4 of those were over 200 days old. After the temporary court order was implemented, the police chief quickly moved on this backlog, and final discipline decisions are public on MPD's website for the first time. As part of the temporary court order, the city and MPD were required to make these changes directly into their policies. This ensures that they stay in effect even after this investigation ends. What has taken other cities years to implement, we did in the first week of this investigation. And that was just the first week. It's been nearly 2 years, so let me talk about what we've been doing since then and the investigation itself. The team of investigators conducted a comprehensive investigation that looked at the City of Minneapolis and the Minneapolis Police Department over the past 10 years. You'll see here ride-alongs and interviews with many MPD officers occurring in every precinct, in person, all during the height of COVID. We owe the rank and file of the MPD a lot of gratitude for their forthcoming and honest feedback. We heard recurring themes about the need for tools, resources, and strong leadership that is essential for success. You'll see here that the team of investigators watched approximately 700 hours of body-worn camera footage. They observed 87 hours of academy training, and they reviewed 480,000 pages of city and MPD documents, such as training materials, policies, assessments, emails, social media, and discipline records. I specifically want to hold space for the over 2,200 community members who we interviewed or provided reports to our agency about their experiences, as well as the 15 listening sessions, including many hosted by organizations and neighborhood associations across Minneapolis. I want to thank every community member who shared their experience with investigators throughout this investigation. The Minnesota Department of Human Rights also worked with nationally recognized policing experts to complete this investigation. This included policing practice experts at 21 CP, many of whom formerly served as police chiefs across the country. We also worked with a renowned policing statistician and professor of criminology, Greg Ridgway, at the University of Pennsylvania, where he is chair of the Department of Criminology. This investigation would not have been possible without a team of lawyers and staff from Kirkland & Ellis, which provided a tremendous amount of pro bono support. This included support from Lisa Madigan, the former Illinois Attorney General, currently a partner at Kirkland & Ellis. I really want to thank everyone who supported this investigation to make sure that we got it right. So what are the findings? After completing this extensive investigation, the Minnesota Department of Human Rights finds that the city and Minneapolis Police Department engaged in a pattern or practice of race discrimination in violation of the Minnesota Human Rights Act. Throughout this investigation, the Minnesota Department of Human Rights determined that this pattern of race-based policing is caused primarily by an organizational culture that can be described in 3 ways. First, flawed training, which emphasized a paramilitary approach to policing. Second, deficient accountability systems that are designed to not hold officers accountable for misconduct and therefore fail to hold officers accountable for misconduct. And lastly, former and current city and MPD leaders who have not collectively acted with the urgency, coordination, and intentionality necessary to address racial disparities in policing, to improve public safety, and increase community trust. I will come back to each of these with more detail later in the presentation. But let me move on now to discuss where we find this pattern or practice of race discrimination. We found a pattern of practice in race discrimination first in racial disparities, in how MPD officers use force and conduct traffic stops against people of color, particularly Black community members, compared to white community members in similar circumstances. We found a pattern of race discrimination and race-based policing in how MPD officers use covert social media to surveil or falsely engage with Black leaders, Black organizations, and government officials unrelated to criminal activity. We also see MPD's officers' consistent use of racist, misogynistic, and otherwise disrespectful language. Let's start by digging into this first one, racial disparities in how MPD officers use force and conduct traffic stops against people of color, particularly Black community members. In the investigation, the Minnesota Department of Human Rights looks at when MPD officers use force. Now, every police department uses force, but officers should not use more severe force against Black people. In fact, it's discriminatory and unlawful to do so. And our findings show that in Minneapolis, MPD officers use more severe force against Black people than white people do in similar circumstances. And we specifically look at neck restraints and chemical irritants when we looked at use of force. And here we found MPD officers are more likely to use neck restraints against Black community members compared to white community members in similar circumstances. We also found that MPD officers are more likely to use chemical irritants against Black community members compared to white community members in similar circumstances. Next, we looked at traffic stops. And we analyzed traffic stops because they are one of the most common ways that MPD officers and community members interact. And if you were pulled over by an MPD officer from January of 2017 through 2020, then your stop is reflected in this data around traffic stops. Here we found that MPD officers are more likely to stop vehicles with people of color and Indigenous individuals, and they treat Black and white individuals differently once they have pulled someone over. So let's start by looking at the decision to make the stop itself. MPD's data shows that MPD officers are more likely to stop a car with people of color and Indigenous community members when their race is visible during daylight hours compared to when it is dark outside. Okay, so why is this important? Why does it matter that we look at daylight versus night? It matters because during daylight hours, it is more possible to see someone's race or ethnicity. So when an MPD officer has the potential to see the race of the people in the car because it's daylight, they are more likely to choose to stop a car that has a person of color or an Indigenous community member in it compared to when it is dark outside and the race of the people in the vehicle is less visible. Now, importantly, this racial disparity in traffic stops exists across Minneapolis. It's not the result of traffic enforcement practices in a single precinct. So none of this can be explained or excused away by one precinct. Let's look next at what happens after an officer decides to stop a vehicle. Now, MPD's data shows that officers are more likely to stop Black community members for longer. They're more likely to search Black community members or their vehicles. They're more likely to cite Black community members, use force against Black community members, and arrest Black community members during a traffic stop. And this is when compared to white community members in similar circumstances. And that's important, that similar circumstances thing, and I'm going to go back to that here in a second. But let me just note real quick that MPD's data does not contain sufficient information for a similar analysis for Latino, Asian, Indigenous, or other racial groups for this specific type of analysis. However, MPD does have data to analyze looking at Black individuals, and here you see this pattern of race-based policing occurring across the board. Again, we found these patterns throughout the city. So none of this can be explained or excused away by one precinct. So I mentioned similar circumstances, and so I want to take a minute here to talk about the methodology behind this analysis because it's important. How did we determine that race is the likely reason for this difference? Since Black individuals comprise approximately 19% of the Minneapolis population, anything over 19% of all searches conducted by MPD officers of Black individuals would be disproportionate, a proportionality analysis. Here you see that analysis. From January 1, 2017 to May 24, 2020, MPD's data shows that 78% of all searches conducted by MPD officers or searches of Black individuals or their vehicles in MPD's 5 precincts across Minneapolis. Now, despite the substantial disproportionality of searches that you see here, some city MPD leaders and some MPD officers will say that this disproportionality is due to factors other than race. As an example, someone may explain that MPD officers patrol parts of the city that have more crime, so geography is the primary reason for this disparity. So to consider this, we did additional analysis that looked at what happens when MPD officers and Black community members are in similar circumstances, and what happens when MPD officers and white community members are engaged in similar circumstances, to see if they're treated the same or differently in those circumstances. This is really an apples-to-apples analysis. We're really looking at the same and similar circumstances to make sure that we can compare it. And what we see here, and so the way we accounted for this analysis and the way we did this is we controlled for and we accounted for factors. So we controlled for geographic location. We controlled for the year, the month, the day, even the time of day. So those cannot be the explanations, nor can they be the excuses for race disparities. This means that where there is a difference, race is the likely reason for this difference. And you see, when comparing Black and white community members in similar circumstances, MPD officers are almost 2 times as likely to search Black community members or their vehicles. Let's next move to use of covert social media. Now, law enforcement officers may have legitimate reasons to track social media activity. Police departments may specifically have a reason to use covert social media if there is a clear investigative purpose to advance public safety. However, a review of MPD's covert social media accounts from at least January 2010 through December 2020 demonstrates that MPD officers used covert or fake social media accounts to surveil and engage Black individuals, Black organizations, and elected officials unrelated to criminal activity. So there's no public safety objective. Okay, so what is a covert account? It's an account where an MPD officer is using MPD's social media account. They are using a fake name, a fake picture, and are presenting as someone that is different than who they really are, so not an MPD police officer. Here, our focus was on MPD officers using MPD covert social media accounts unrelated to criminal activity. So let's talk about that. In one post, an MPD officer used a covert account to pose as a Black community member to send a message to a local branch of the NAACP criticizing the group. MPD officers also used MPD's covert social accounts to send private messages criticizing elected officials. They did this while posing as community members. Now, police officers using covert social media to contact and criticize elected officials can really undermine the democratic process because false communications can distort elected officials' perspectives of positions taken by community members. And you'll see in our findings that we talk about how police officers can use covert social media when they're doing so for a clear investigative purpose to advance public safety. And police departments that use covert social media must have clear procedures and clear accountability mechanisms in place to ensure that covert social media has a close nexus to a true public safety objective and that it's not being used in a discriminatory manner. It is not the case here. According to, let's last look at where MPD officers engage in a pattern of race discrimination through racist, misogynistic, and disrespectful language. And here we looked at body-worn camera footage, discipline records, statements from community members, interviews with MPD officers and prosecutors, and we found that some MPD officers and supervisors use racist, misogynistic, disrespectful, and offensive language. And they use this language to everyone, to criminal suspects, to witnesses, to bystanders, and to fellow MPD and city officials themselves. City employees. In a second, we're going to return to the slides about how this pattern of race discrimination is caused by organizational culture. We'll talk about how this is because It is created and demonstrated through consistent behavior. Organizational culture is created and demonstrated through consistent behavior. An MPD maintains an organizational culture where officers consistently use racist, misogynistic, and disrespectful language. Furthermore, MPD does not uniformly and consistently hold officers accountable for using this language. This consistent behavior manifests and reinforces this kind of organizational culture. So let's go back to the slide here that talked about this pattern of race-based policing being caused by an organizational culture, and start with trainings. Now, MPD's data shows that MPD officers are using unnecessary and excessive force, that they are escalating situations instead of de-escalating situations, and that there is race-based policing occurring. So it is not surprising that trainings are infused with a paramilitary approach and that warrior mindset given this data. Now, although the city formally banned official warrior-style training in 2019, much of MPD's current trainings continue to embed this warrior mindset in its officers. On the very first day of academy training in 2021, police recruits were told instant and unquestioned compliance is an order. This mentality of unquestioned obedience is endemic within MPD's organizational culture and undermines MPD's written policies. For example, if the written policy is that an officer has the duty to intervene when they see unlawful use of force occurring, the actual policy of instant and unquestioned compliance undermines the existence of that written duty to intervene policy, rendering it useless. This instant and unquestioned compliance is also the same tone that many MPD officers set with community members, which sets up a real us versus them dynamic with community members that they are sworn to serve and protect. MPD also fails to provide comprehensive cultural competency training for officers. In fact, when MPD shortened its 2021 Academy training session, MPD eliminated conversations about practicing cultural competency when working with specific groups of color and Indigenous community members. In a city with such racial and ethnic diversity, the choice to eliminate these trainings is concerning. This decision also occurred after the city was under investigation by both the state and federal government for potential race discrimination within the MPD. So the decision to eliminate these trainings then was frankly surprising. Now, trainings are important because they are where the culture of MPD is taught. They're where culture norms are reinforced. They're where MPD officers learn what happens if they violate these culture norms. And here, the Minnesota Department of Human Rights found that MPD's trainings reinforce a culture that exacerbates a pattern of race-based policing. Next, let's talk about flawed accountability systems. I'm going to start by first talking about supervisors tacitly or directly approving inappropriate and potentially unlawful behavior, because supervision and supervisors is the first line of accountability long before you move into any more formal sort of accountability systems. So I want to give you an example that's illustrative of this pattern of supervisors approving inappropriate and potential unlawful behavior. So in one example, an MPD officer came into a bedroom to find an unarmed black 14-year-old sitting on the floor using his phone. The MPD officer demanded the kid stand up, but the kid did not stand up fast enough for the officer. All of this was happening very quickly. The MPD officer took out his flashlight and hit the 14-year-old kid across his head with the flashlight, causing the kid to bleed out of his ear right here. Next, the officer grabbed the kid by the neck and did what's called an unconscious neck restraint, which, as the name suggests, means the MPD officer choked the kid until he was unconscious. Following this incident, the supervisor reviewed the file, and the supervisor approved this use of force and said there was no violation of policy or law. By deeming this officer's use of force appropriate, the supervisor effectively authorized the officer to continue using such egregious force in the future. Then, if an investigation were to occur, and in the example I just highlighted, no timely investigation occurred, but if one were to occur, investigators regularly fail to properly investigate a significant percentage of police misconduct cases. This includes misconduct cases where there may be problems with race discrimination. Next, MPD fails to consistently hold officers accountable. For instance, if an investigation does occur, oftentimes officers are supposed to receive coaching. This isn't discipline, but coaching. And the investigation found that 37% of the time officers were supposed to receive coaching, the supervisors simply did not coach that officer. That means the officers did not get the support, they did not get the resources, and they did not get the training that they clearly needed to be successful. This means that in these moments when supervisors are failing to provide this coaching, the supervisors are setting the officers up for continued failure. Finally, when discipline decisions go to arbitration, and it's rare, it's a little bit over 20 in the last 10 years for discipline decisions, they are often reduced to preventable factors within the city and MPD's control. One arbitration case particularly demonstrates how factors within the city and MPD's control impact arbitration outcomes. In a case from 2019, an arbitrator reduced a termination decision to an 80-hour suspension. In this situation, an officer had potentially used excessive force when making an arrest. Here, the city and MPD did the right thing, and they relieved the officer of duty, requiring the officer to stay home before eventually assigning the officer to a desk position with no contact with the public, and initiated an investigation. The investigation resulted in a recommended finding that the officer had, in fact, used excessive force. However, the day after the finding was issued, an MPD leader decided to send the officer back to regular duty with full enforcement responsibilities, then further relied on that officer as a field training officer to train other officers. Subsequently, it took over a year for the city and MPD to ultimately terminate this officer. So when the arbitrator looked at this case, the arbitrator overturned the decision to terminate because, in large part, of the decisions of MPD to return the MPD officer to regular duty, including field training, to do so after a recommended finding of excessive force had come out, and that it took an additional year for the officer to be terminated. This example highlights the factors that are fully within the control and of the city and MPD to prevent reduction in arbitrations. Importantly, community members of color and Indigenous individuals especially experience the ramifications of the failure of these accountability systems to address race-based policing. Lastly, let's talk about this pattern of race-based policing being caused by an organizational culture of a lack of collective action by city and MPD leadership. Now, another way we can understand culture is by looking at leadership and seeing what they say and what they do. As a result of a lack of coordinated and sustained action to address racial disparities in policing, city and MPD leaders throughout at least the past decade have allowed MPD to maintain an organizational culture that demands unquestionable compliance, emboldens aggressive escalation, and is adverse to accountability. Leadership is critical. Leadership is critical to bringing about organizational change and address race-based policing. Throughout our investigation, former and current city and MPD leaders all acknowledged that there is a problem with MPD's organizational culture and that they knew that it was resulting in racial disparities. And yet, over the 10 years that our investigation looked at, let me clarify, over the 10 years that our investigation looked at, there certainly have been instances where both city and MPD leaders have acted. For instance, Minneapolis band warrior style training, that's something that I mentioned earlier in this presentation. Yet in some cases where city and MPD leaders attempted to implement change, current and former city and MPD leaders have not collectively acted with the necessary urgency, coordination, and intentionality that is required to create and maintain a strong public safety system, which includes eliminating discriminatory policing. Furthermore, in some cases where city and MPD leaders attempted to make changes, those attempted changes were eroded by city and MPD leaders providing inaccurate or misleading information to the public. When city and MPD leaders provide inaccurate or confusing information, it sows distrust, it amplifies that confusion, and it undermines meaningful attempts at change. So leadership is critical. And our investigation identified that there has been a vacuum of collective action, of collective sustained action from key city and MPD leaders. And the organizational culture at MPD has existed unchecked for resulting in unlawful discriminatory policing. It undermines public safety, and it's been going on for at least the past decade. This brings me to the last finding that you'll see on page 8 of the determination, if you're following along. And this is that the investigation finds that without fundamental organizational culture change, reforming MPD's policies, procedures, and trainings will be meaningless. This is a big statement, but I think it speaks to the scope of the challenge that lies ahead. So let's discuss what's next. So this process does not start and it does not end with these findings. The city has made and continues to make efforts to address these concerns, and as we note throughout the determination, the city can make immediate changes that are fully within the control of the city and MPD that do not require modifications to any collective bargaining agreement or state law. Now, Minnesota Department of Human Rights will next work with the city to develop a consent decree to address this discriminatory race-based policing in Minneapolis in violation of the Minnesota Human Rights Act. Now, a consent decree with the city of Minneapolis and the Minneapolis Police Department is really unprecedented. Unlike previous events to reform policing in Minneapolis, a consent decree is a legally binding agreement that the parties are required by law to follow. A consent decree lays out specific changes that the city and MPD will be required to make to address the pattern of race discrimination in violation of the Minnesota Human Rights Act. Because a consent decree is issued by a judge, it is the judge who holds parties accountable, with monitors that report the progress directly to the judge. Importantly, a consent decree also lives on past all election cycles, which provides for that sustained action that is necessary here for success. And so it's not subject to the whims of changing elected officials. A consent decree is also a tool. A tool can be very powerful, but it is only a tool, which is why we want to be just as thoughtful in this next phase to get this right. To that end, the Minnesota Department of Human Rights will meet with community members, MPD officers, city staff, and other stakeholders to gather feedback on what should be included in a consent decree to address the race-based policing we have noted throughout our findings here. Anyone is welcome to send information for potential changes in a consent decree by going to the website. It's listed here at mn.gov/MDHR. And we'll continue with additional information in the coming weeks about that engagement. I started this presentation by talking about how, following the murder of George Floyd, demands to end discriminatory policing practices reverberated across the world. Those demands remain just as true and urgent today with this announcement of the investigative findings, which paints an unsettling picture of the city of Minneapolis and the Minneapolis Police Department engaging in a pattern of racial discrimination over the last decade. Now, race-based policing is unlawful, and it harms everyone, especially people of color and Indigenous community members, sometimes costing community members their lives. I look forward to the work ahead with the city, with MPD, with community members to improve public safety by reversing unlawful discriminatory policing practices in violation of the Minnesota Human Rights Act. Thank you very much. We can open it up to any questions.